Welcome to the deep dive. We are pulling up a pretty hefty stack of source material today. We're tackling something huge, really a major legal shift in modern India.
Indeed, it's a fascinating and incredibly important topic.
And the question we're grappling with, it's vital for anyone interested in democracy, in the rule of law globally, actually. Did India truly decolonize its justice system?
That's the crux of it.
Our sources, they all point to this. Well, this legislative earthquake back on July 1st, 2024, India swapped out its core colonial-era legal codes. We're talking the big three: the Indian Penal Code, the Code of Criminal Procedure, and the Indian Evidence Act. Almost 165 years old, some of them.
Right, replaced with the Bharatiya Nyaya Sanhita, the BNS, the Bharatiya Nyaya Sanhita BNSS, and the Bharatiya Saksha Adhiniyam BSA.
Exactly. Now, this was presented, certainly internationally, as this massive, overdue break from the British Raj. The world's largest republic finally shedding its colonial legal skin.
That was the narrative, yes. A fresh start.
But, and here's where our deep dive really begins. The expert analysis, the legal scholars, the policy researchers we've looked at, they argue quite strongly that these reforms, largely cosmetic. So our mission today is to really test that claim. We need to dive into the evidence that suggests those foundational chains of colonial control might have just been, well, polished up and given new names.
That's precisely the core thesis we need to unpack for you. And the critique here, it isn't just technical legal stuff. It's philosophical, really.
How so?
The sources argue the legal system's foundational mindset is still colonial. Why? Because it was designed fundamentally for control, not for service to the people.
Okay.
It keeps prioritizing state authority over individual rights. And, crucially, it treats the citizen like a subject who has to beg for justice rather than the master of a sovereign democratic republic.
So the argument is, if the system was built to rule, not to serve.
Simply changing the chapter titles, the section numbers, isn't going to change its fundamental DNA. It's still operating on that old colonial logic.
Okay, let's unpack this then, because, replacing three huge foundational laws. That sounds like a massive structural change. Surely something significant changed on paper. What were the headline changes, and where does the analysis say the old colonial logic sneaked back in?
Well, on the surface, you're right. The reforms look quite impressive. Take the BNS, the new penal code, replacing the old IPC.
Right.
They did reduce the total number of sections, down from 511 to 358. And they definitely pruned some genuinely archaic provisions, things like outdated punishments, Plus, they added new modern offenses covering things like organized crime, cybercrime, terrorism.
So, okay, proponents could definitely argue they streamlined it, updated it for the 21st century. That sounds reasonable. How does the source material push back against that?
The counterargument digs into the substance, not just the structure. While the section numbers and classifications changed, detailed analysis shows that nearly 70%.
70?
Yes. Nearly 70% of the old IPC's core concepts and substance survive within the new BNS. We're talking about the basic definitions for property crimes, offenses against the body, the overall penalty structures.
So the underlying legal scaffolding is mostly the same?
Substantively, yes. The effect is like giving a book a new cover and chapter headings, but keeping most of the original text. The mechanisms that govern things like administrative burden, judicial interpretation, the very things that clog the courts, they remain largely intact.
Which means that hierarchical foundation, the state supreme, the citizen subservient, that persists too.
That's the core argument. It persists because the tools of control weren't fundamentally altered.
Okay, that 70% figure is huge. It implies most of the mechanisms for enforcing that state-centric control just got copied over. Let's drill down into some specific examples the sources highlight, starting with maybe the first point of contact, police power.
Yes, the wide discretionary powers of the police. This is probably the most damaging carryover, according to the analysis. Under the old CRPC, the Code of Criminal Procedure, Section 41 was notorious.
Right, the power to arrest without a warrant.
Exactly. For what are called cognizable offenses, basically. Serious enough offenses where police can start investigating immediately, without needing a judge's permission first.
Okay, and the new code, the BNSS, what did it do with Section 41?
Well, BNSS Section 35 continues that exact same authority. And some legal readings suggest the language used might even be broader, giving the officer on the ground even more latitude.
And crucially,
the reform missed the chance to introduce any mandatory standardized oversight right at the point of arrest. Things like, say, automatically requiring body cam footage for review, or mandatory immediate reporting to a supervisor with details, or even requiring a quick judicial check after the arrest but before that first 24-hour detention period is up.
So the basic power for an officer to act first, without a magistrate's warrant or any immediate external check, that just remains. Cementing power in the position, not in the rights of the person being arrested.
Precisely. It leaves power concentrated at the lowest level of the enforcement chain, often without effective, immediate external accountability. That's classic colonial control logic.
And that lack of accountability, it sort of feeds itself, doesn't it? What about when things go wrong, like serious abuses, custodial deaths?
Looking at accountability after the fact, the new BNSS procedural code, well, it still relies entirely on executive-controlled magistrates.
Yeah.
Sections 174 to 176 empower these magistrates to order inquiries into serious abuses, like custodial deaths or severe misconduct.
Wait, so after this massive overhaul, there's still no provision for, say, an independent citizen complaints board, an external body to investigate the police?
Not built into these core codes, no. The citizen essentially has to appeal to the very system, the executive branch, which oversees the police that allegedly violated their rights. You're asking the system to investigate itself.
That seems fundamentally flawed.
It's a huge red flag for the critics. It suggests that the core master-servant dynamic, where the state apparatus protects its own, hasn't been dismantled.
Okay, let's talk about another really famous colonial tool, sedition. IPC Section 124A, used for ages to stifle dissent, right? Journalists, activists. That was repealed. Surely that's a clear win.
The name sedition in Section 124A were indeed repealed. That was symbolically significant. But its spirit seems to have been reinvented in the new BNS Section 150.
Reinvented how?
Well, they removed the specific old language about exciting disaffection towards the government. But the new law criminalizes acts like exciting secession, armed rebellion, or, and this is the key phrase, subversive activities.
Subversive activities. Okay, alarm bells are ringing. What's the problem with that phrase, according to the sources?
The problem is its vagueness. Critics argue it's so broad, so undefined, that it gives the state enormous power to potentially criminalize robust political criticism, organize peaceful protests, or any dissent that seriously challenges government policy.
Without clear lines.
Without adequate safeguards to clearly distinguish genuine threats to national security from legitimate, even harsh, political opposition. So, the potential for the state to use the law to suppress political rivals or inconvenient activists, it persists just under a different, less historically toxic label.
Right. Let's shift to basic procedural rights. You know, the kind of things we associate with modern democracy, like Miranda rights in the U.S. or cautions in the U.K. Did the new BNSS or BNS introduce anything like a mandatory Citizen Bill of Legal Rights that police must inform people of?
No. That's a glaring omission, according to the analysis. There's no explicit legal obligation baked into these new codes requiring police to systematically inform citizens of their fundamental rights upon arrest or during questioning.
That seems like, well, like decolonization 101, doesn't it? If you're truly putting the citizen first, telling them their rights seems fundamental.
Absolutely. If the goal was genuinely to shift from subject to citizen, from ruled to master of the republic, instituting a clear charter of rights and mandating its disclosure would likely have been a cornerstone reform. The silence on this point is quite telling.
And this lack of rights awareness feeds directly into another huge issue, delay. The grinding delays in the system, which disproportionately hurt the poor.
It does. BNSS Section 187, which covers custody rules. It still allows police to seek 15 days of judicial custody initially.
Okay.
But crucially, this can still be extended up to 60 days or even 90 days in some serious cases just for the investigation phase.
Oh,
and the law doesn't impose a strict mandate on the police to transparently justify why they need so much time, nor does it automatically trigger high-quality legal aid from day one unless the accused specifically requests it and qualifies.
So the system's design essentially still allows thousands of under-trial prisoners, many poor and marginalized, to be trapped in jail for months, sometimes years, just while the investigation is ongoing.
Exactly. The process itself becomes a form of punishment, often resulting in pretrial detention that might even exceed the eventual sentence, if any. It's a clear conflict with Article 21 of the Constitution, the right to life and personal liberty.
Which brings us back to that central critique you mentioned earlier.
Yes. If the core procedures, the ones enabling broad police discretion, allowing potential political influence, maintaining systemic opacity, facilitating these long delays, and failing to mandate rights if these are fundamentally untouched, Then how can this reform be truly called decolonization? The sources conclude it's more like putting a modern veneer on the old master-servant model, legitimizing the colonial mechanisms under a new, supposedly Indianized banner.
Okay, this is where I think it gets really visceral. We move from the legalese, the statutes, to the lived experience, sometimes the terrifying lived experience, of the average person interacting with this system. The sources argue this colonial mindset isn't just abstract theory, it's baked into the very DNA of law enforcement.
That context is absolutely vital. We have to remember, the police force as structured in India largely originates from the 1861 Police Act, and its purpose then was explicit: suppress resistance to British rule, manage resources for the empire, and enforce alien laws on a subject population.
It wasn't set up as a community service agency.
Not at all. It was conceived as an instrument of imperial control. And that DNA, that inherent ethos of being an authoritative, sometimes oppressive force, rather than a public servant accountable to the local community critics, argue it's still deeply embedded in the operational culture today.
The sources really back this up, noting that for many average Indians, there's still a sense of dread about even entering a police station.
Yes, having to plead sometimes for hours just to get a basic service like filing a first information report in FIR or navigating the bail process fairly. This interaction is often marked by indifference, intimidation, or worse.
The demand for informal payments, bribes.
Exactly. It points to a situation where justice isn't automatically delivered. It's something you might have to negotiate for or even pay for. Justice becomes, in effect, commodified.
And the consequences of this kind of unchecked authority, this colonial hangover, they manifest as a huge accountability deficit, right?
Devastatingly so. Let's try to quantify that deficit. The reports on abuse are just staggering.
Yeah.
Reports of police torture, custodial deaths, extortion, they are alarmingly common. The National Human Rights Commission, for example, tracked 1,723 deaths in custody in just 1 year, 2019.
1,700 in 1 year.
Yes, and this highlights a system where, despite some court directives like the landmark Prakash Singh judgment in 2006 recommending police complaints authorities, the fear of genuine internal or external accountability often seems minimal on the ground.
And the sources are clear. This lack of accountability, this culture of impunity, it's not just confined to the police, is it? It's depicted as more systemic.
Precisely. The analysis points to pervasive corruption that infiltrates multiple levels of governance. It mentions ministers, politicians, government officials, even extending into sectors like banking and healthcare. Transparency International's 2019 survey, for instance, found over half of Indians surveyed reported paying bribes for basic public services.
Over 50%.
It suggests the rule of law itself is widely undermined, potentially making the system a tool for those with power and connections, rather than a shield for the ordinary, powerless citizen.
Okay, shifting focus slightly, let's look at the courts themselves. The crisis there is often summed up by that famous, almost cinematic phrase in India: Tarik pe tarik, date after date after date, delay.
The crisis of justice delivery, purely in terms of delay and backlog, is monumental. The figures are almost hard to comprehend. Nationally, as of early 2025, the total number of pending cases across all courts was estimated at over 50 million.
50.
Yes. And if you break that down, the vast majority, around 47 million, are stuck in the district and subordinate courts, the first point of contact for most people. Even the Supreme Court, the apex body, struggles with the backlog, fluctuating around maybe 88,000 matters.
50 million cases pending. We really need to let that number sink in. For individuals caught in that system, it means trials can literally drag on for years, sometimes decades.
Absolutely.
Yeah.
It exhausts people financially, emotionally. People lose livelihoods waiting for resolution. It's a profound form of procedural injustice. The process itself becomes the punishment, regardless of the eventual outcome.
And this ties directly into accessibility, doesn't it?
Directly. It undermines the whole principle of equality before the law. The sources repeatedly stress that justice has effectively become a luxury good.
A luxury good.
Yes, because the costs are prohibitive for so many. Think about it. Lawyer fees, often exorbitant. Travel expenses back and forth to court. Lost wages for every day spent in proceedings. It means that, in practice, wealth and influence can significantly determine case outcomes and timelines. The poor and powerless are often simply priced out or ground down by the delays. The system uses delay as an exclusionary mechanism.
It's clear the operation of the system feels colonial in its impact, slow, often inaccessible, favoring the powerful. But let's connect this back to the structure of the judiciary itself. Where did this whole pyramid set up Supreme Court, High Court, subordinate courts actually come from?
The sources trace this entire integrated judicial structure directly back to the colonial era. It wasn't designed for an independent republic. It was built piece by the British for imperial administration and control.
Can you trace that lineage?
Sure, the modern origins can be seen with the Regulating Act of 1773, which established the first Supreme Court, but in Calcutta in 1774. Then the Indian High Courts Act of 1861 solidified that middle tier, the High Courts.
And the current Supreme Court of India.
That was inaugurated on January 28, 1950, just after India became a republic. But it's essentially a direct continuation, a renaming of the Federal Court of India. And the Federal Court itself was created under the Government of India Act of 1935, a purely colonial piece of legislation designed by the British Parliament.
So post-independence, India basically just adopted the existing colonial judicial structure wholesale.
That's the critique laid out in the sources. Instead of designing a new judicial architecture tailored for a sovereign democracy and its citizens, India inherited the old imperial building, dusted it off, and carried on. The argument is that the structure itself carries the imprint of its original purpose: control, not service.
Okay, so we've established a pretty strong case from the sources that just rewriting the law books, the BNS, BNSS, BSA, wasn't enough. It didn't fundamentally decolonize the system. The solution then has to be structural.
Exactly. Cosmetic changes aren't enough.
And the sources we looked at, they don't just critique, they propose a comprehensive vision for transformation. It seems to be built on 5 key pillars, designed to fundamentally shift the state's logic from ruling subjects to actually serving citizens. Let's dive into Pillar A. This seems to tackle that accountability deficit head-on.
Pillar A is arguably the most radical and potentially transformative proposal, establishing a fully independent constitutional body. They call it the Citizen Oversight Authority, or, more provocatively, the Police of Police, the POP.
Police of police. Wow, that's a statement in itself. How would this body be set up to ensure it's actually independent? Because that's always the challenge, right? Political interference.
Absolutely. The design emphasizes insulation from political meddling. It would need constitutional status, putting it on par with bodies like the Election Commission of India, ECI, or the Comptroller and Auditor General.
And the mechanisms for independence.
Key mechanisms would include strictly merit-based recruitment for its leadership, fixed, non-renewable terms to prevent lobbying for extensions or reappointment, and critically, an independent budget protected by law, not dependent on yearly government approvals. It needs financial autonomy.
Okay, independent structure. What about its mandate? Who does the POP oversee? Just the police?
No, and this is crucial. The mandate is deliberately broad because the problem of unaccountable power is seen as systemic. The POP would oversee and regulate not just the police and prosecutors, but also government ministers, politicians, senior bureaucrats, potentially even bankers handling public funds, and other high-level public servants.
So it's tackling corruption and misuse of power across the board, not just law enforcement.
Exactly. The philosophy is that abuse of public trust is an institutional problem requiring a unified, powerful, independent watchdog.
That makes sense. What teeth would the POP have? What could it actually do?
It would need significant powers. Things like investigating complaints of misconduct against any public servant within its ambit, proactively conducting covert sting operations or unannounced audits to test integrity and efficiency, offering robust protection for whistleblowers who expose wrongdoing, and issuing recommendations for disciplinary action that are binding, not just advisory.
Binding recommendations. And what about enforcement? Does it just recommend action to others?
No, this is another key element. The proposal suggests the POP should have its own judicial arm. Think of it like a specialized court-martial system designed for swift, fair, transparent trials of the cases it brings forward against public servants it has investigated. The goal is continuous, rigorous oversight that actively cleanses the system and enforces meritocracy.
Okay, that's Pillar A, a powerful independent watchdog. Let's move to Pillar B. This seems to directly address that point about citizens not being informed of their rights.
Pillar B is about institutionalizing a citizen rights charter and making its disclosure mandatory. The proposal is simple but profound. The law must require every police station, every courthouse, to prominently display a clear, easy-to-understand citizen's charter of legal rights.
Display it physically?
Yes, physically display it. But more importantly, police officers must be legally obligated to orally inform citizens of their key rights during any significant interaction, arrest, detention, formal questioning.
But how do you enforce that? We talked about the culture of intimidation. How do you make sure officers actually do it?
Enforcement is critical. The proposal suggests mandatory digital acknowledgement for every complaint or FIR filed. When you file a complaint, you get an immediate, trackable digital receipt. No more come back tomorrow or lost papers.
An audit trail.
Exactly. And paired with that, swift and meaningful departmental penalties may be automatic salary deductions or suspensions for officers or officials who fail to provide this digital acknowledgement or fail to inform citizens of their rights as required. It creates accountability for the most basic interface between the citizen and the state.
Okay, makes sense. Pillar C tackles the monster of delay, the Tariq crisis.
Yes, this is the time-bound justice and legal accountability framework. The big failure of the new BNS and BNSS, according to critics, was the lack of strict, enforceable timelines for legal processes.
So Pillar C proposes
Mandating statutory deadlines for every stage. A deadline for registering an FIR after a complaint is made. A deadline for the police to file a charge sheet after investigation. A deadline for the court to hold a bail hearing. A deadline for final judgment. Fixed timelines across the board.
But again, the enforcement question. Deadlines are often missed. What's the stick?
This is where the proposal gets innovative. It demands guaranteed automatic review and, crucially, financial compensation paid by the state to the citizen for cases delayed beyond these statutory deadlines without justification.
So the state pays for its own inefficiency.
Precisely. It shifts the financial burden delay from the citizen back onto the system itself. That creates a powerful incentive for efficiency. And alongside this, continuous randomized performance audits of lower courts and police stations, measuring things like disposal rates and adherence to timelines, with the results made public. Transparency drives performance.
Pillar D then focuses on accessibility, making sure justice isn't just for the wealthy.
This is the legal aid and compensation framework, the core idea. Justice is a fundamental right, not a commodity you buy. The proposal includes creating a universal, user-friendly digital portal for accessing legal aid.
Making it easy to get a lawyer.
Yes, connecting people with registered, accountable advocates quickly and easily. But the truly transformative part, again, is mandatory state compensation.
Compensation for what, specifically, under this pillar?
Compensation for victims of proven wrongful arrest or custodial abuse. And, very importantly, compensation for citizens who are acquitted after enduring a prolonged trial.
So if the state accuses you, makes you go through years of trial, destroys your reputation and finances, and then fails to prove its case,
the state must be legally required to compensate you for that lost time, the financial ruin, the emotional distress. It acknowledges the immense harm caused by flawed prosecution and protracted trials, even in case of acquittal.
And finally, Pillar E. This recognizes that laws and structures are only as good as the people implementing them. It's about the mindset.
Exactly. This is civic re-education of law enforcement. Current training often emphasizes hierarchy, obedience, control remnants of the colonial model. Pillar E demands mandatory annual retraining focused squarely on constitutional duties, ethics centered on the citizen, and the inherent dignity of every person they interact with. It's about fundamentally shifting the internal culture from control to service.
Retraining is one thing, but how do you measure if the culture is actually changing?
Through feedback. The proposal suggests institutionalizing public feedback loops. Imagine systems where citizens can rate the quality of service received at a police station or from a specific officer, perhaps digitally. And these ratings, along with metrics on how complaints against officials are resolved, should be publicly visible. It creates transparency and makes citizen satisfaction the key performance indicator. It forces a service-oriented mindset. Okay, so those 5 pillars address the executive, the police, the procedural aspects. But the sources stress we also need to tackle deep structural flaws within the judiciary itself. That colonial architecture needs more than just renovation. It needs rebuilding, focusing on impartiality and accountability within the judiciary.
Right, so let's look at the judicial blueprint proposals from the sources. They suggest changes starting right at the top, the Supreme Court. Why the call for increasing its size and implementing fixed terms?
The suggestion is to increase the Supreme Court's strength significantly, maybe to around 45 justices. This is partly pragmatic to handle the huge backlog and allow for more specialized benches. But the key reform is implementing a single, non-renewable term, say 12 years, or perhaps until a fixed retirement age like 72, whichever comes first.
Why non-renewable?
It's designed to end the potential for long-term judicial entrenchment, ensure a regular influx of fresh legal thinking, and, importantly, limit the political capital or influence a judge might accrue over a very long career, potentially spanning decades. And adding mandatory health or cognitive checks after a certain age, say 65, is just about ensuring continued capacity for the demanding role.
Makes sense. But the proposal that really jumped out at me was the one aimed at eliminating judge shopping, the perception that powerful litigants might try to get their cases heard by specific judges deemed favorable.
Ah, yes, the randomized benches proposal. This is quite radical compared to current practice.
Right.
Instead of the Chief Justice assigning cases to benches, the sources recommend that for significant cases, especially constitutional ones, requiring larger benches of, say, 7 or 9 justices,
Yes.
those justices should be selected randomly, like a lottery draw, using a publicly auditable algorithm. And crucially, this random selection must happen after the court has already decided to hear the case, not before it's admitted.
Ah, the timing is key. So random selection after admission means litigants, political actors, whoever, can't strategically time their case filing or try to influence who hears it. It preserves impartiality.
That's the core idea. It aims to remove any possibility, or even perception, of bench manipulation. And related to that perception of influence is the issue of post-retirement jobs.
Right, judges retiring and immediately taking up government-appointed positions, often very lucrative ones. The quid pro quo concern.
Exactly. To combat this, the sources mandate a strict mandatory cooling-off period, say 5 years. A retired judge cannot accept any government-appointed role, tribunals, governorships, commissions, until that 5-year period is over. It breaks the potential link between pre-retirement judgments and post-retirement rewards.
Okay, so that's about impartiality. What about accountability of the judiciary, holding judges themselves accountable for misconduct? The proposal is for an independent Judicial Oversight Council of India, JOCI.
Yes, the JOCI is envisioned to tackle 2 major issues with the current system. First, replacing the opaque collegium system used for judicial appointments and promotions with something more transparent, perhaps a weighted peer nomination and voting system involving judges, senior lawyers, and legal academics.
And the second function.
More importantly, for accountability, the JOCI would replace the current highly politicized process of parliamentary impeachment for removing judges accused of serious misconduct. Instead, the JOCI would be the independent body responsible for investigating all ethical complaints and allegations of misconduct against judges, from lower courts up to the Supreme Court.
Okay, so JOCI investigates. What happens if they find serious wrongdoing, like corruption? How does the proposed tiered sanction system work? Does JOCI itself remove the judge?
No, JOCI investigates and recommends. For the most serious Tier 1 offenses, things like proven corruption or gross judicial misconduct, JOCI would issue a formal removal recommendation. But here's the critical step. That recommendation does not go to Parliament for a political vote.
Where does it go?
It goes to a specially convened judicial tribunal, sitting within the Supreme Court itself.
A tribunal of judges judging judges. Who sits on it?
The proposal suggests a mixed body, maybe 11 members. Perhaps 5 randomly selected senior Supreme Court justices, 3 highly respected retired judges, and 3 eminent independent law professors. Removal would require a high threshold, a supermajority vote, say, 7 out of 11.
Why is that design taking it away from Parliament so important for decolonization?
Because it aims to depoliticize judicial accountability. It shifts the final decision on a judge's integrity away from political maneuvering or expediency and places it within a quasi-judicial expert framework. It preserves judicial independence from political attack while still enforcing rigorous accountability based on evidence and ethics.
And if this tribunal does vote for removal, what are the consequences?
The proposed penalties are severe, designed as a real deterrent. Removal by the tribunal would mean automatic forfeiture of all retirement benefits, potential criminal prosecution for any illicit gains, and a lifetime ban from holding any future government or public position. The message is, misuse of high judicial power will have absolute consequences.
Now, when we hold these proposals up against what actually exists in other major democracies, the sources suggest India's current system, even post-reform, lags significantly in external accountability, right?
Yes, the comparison is quite stark. India's implementation of police complaints authorities, often recommended but patchily implemented and frequently lacking real power, looks weak compared to established international models.
Like where?
Well, contrast it with the UK's Independent Office for Police Conduct, IOPC. It's a genuinely independent body with significant investigative powers. Or look at France, which has the Inspection Générale de la Police, IGPN, literally nicknamed the Police of Police, designed specifically for rigorous internal and external oversight. These are powerful, autonomous accountability mechanisms that India's recent reforms didn't emulate.
And what about that other corrosive issue, political interference? Powerful people influencing police transfers, promotions, or even case outcomes.
Here, too, the sources suggest India still struggles significantly. Political considerations often seem to drive police postings and transfers, rather than pure merit, sometimes leading to situations like the controversial Sanjeev Pot case. And the influence of wealthy or well-connected individuals can undeniably lead to selective enforcement or justice being delayed or denied, as highlighted in high-profile cases like the Jessica Lal murder trial years ago.
Whereas in many pure democracies.
The emphasis is much more strongly on operational independence and minimizing political meddling. The UK traditionally grants its police forces considerable operational autonomy. The U.S. relies on the constitutional separation of powers and external oversight from bodies like the Department of Justice. Countries like Japan or Germany have very strict civil service rules and internal protocols designed specifically to insulate enforcement decisions from day-to-day political pressures. The integrity of the process is paramount.
So that comparison really hammers home the core point, doesn't it?
It reinforces the central conclusion from the sources. You can't truly decolonize a system just by changing the law books. Genuine decolonization requires tackling the underlying structures and culture. It means, as the sources suggest, potentially abolishing colonial-era administrative structures like the IAS and IPS recruitment systems in their current form, enacting truly exemplary punishments for abuse of power, and, above all, creating strong, independent institutions like the proposed POP and JOCI that guarantee accountability across the entire public sector. It's about fundamentally reorienting the state to serve, not rule. Outro.
So let's try and synthesize this. What does it all mean? Our deep dive today, based on this expert analysis, suggests that India's new laws, the BNS, BNSS, BSA, while they made some modernizing tweaks, fundamentally kept the old colonial operating system running underneath.
The core logic remained.
Those pervasive discretionary police powers, the critical lack of mandatory citizen rights disclosure, the inherited top-down judicial structure, these seem to be direct legacies designed for command and control, not citizen service.
That's the assessment, yes.
And true decolonization, according to this analysis, demands much more than new statutes. It requires deep structural transformation. It means having the political will to implement genuinely independent accountability bodies like this proposed police, the POP, and a Judicial Oversight Council, the JOCI.
And other reforms, too.
Yes, and judicial and administrative reforms that fundamentally shift the state's priorities, making sure the citizen who is supposed to be the master of the republic is actually served by a system that's timely, transparent, and truly impartial.
You know, what's really fascinating here, stepping back a bit, is that this isn't just about legal texts. It's about breaking what one source called a silent contract of servitude.
Explain that.
For over a century and a half, through colonial rule and even for 77 years post-independence, the average Indian citizen interacting with the state's legal arms has often implicitly operated from a position of subservience, assuming they might be seen as guilty until proven innocent, feeling powerless, feeling invisible.
Right.
The ultimate goal of true decolonization, then, isn't just new laws. It's drafting a new social contract, embedding a new relationship where the state systemically, structurally, respects and serves its people as its masters.
We've seen very clearly in this deep dive how systems originally designed for control inevitably end up treating people like subjects, not citizens. So maybe the provocative thought to leave you, our listener, with is this. What hidden colonial logic, or perhaps just logic based on control rather than service, might still be embedded in the foundational institutions of your own country? Think about law enforcement, bureaucracy, maybe even the courts. And what bold structural changes, going far beyond just tweaking the laws, would it really take to shift that deep-seated logic from one of power and obedience to one truly based on service and accountability?